Welcome to Grant or Deny, a government contract claims talk show that breaks down legal arguments and predicts based on the record whether the board will grant or deny the appeal. I'm your host, Kelsi Pilcher, trial attorney with the United States Air Force, and I'm here today with Jennifer Bentley from Covington and Burling's Washington, D.C. GovCon Group. How are you?
I'm good. Thanks for having me.
Good. So we're going to do things just a little bit differently on this episode. Since it's the top of the year, it's only fitting that we look back at 2025 on the top trends and takeaways, particularly with the Armed Services Board of Contract Appeals and the Civilian Board of Contract Appeals. Are you ready to get started?
I am.
Okay, so before we dive deep, let's just do a quick overview. What are the ASPCA and CBCA annual reports?
Each year, the ASPCA and CBCA release an annual report summarizing their work over the prior fiscal year. The reports provide high-level statistics about their caseloads for the last fiscal year and share news about key developments and notes since the last annual report. Especially when compared to previous year's reports, they can provide an interesting snapshot of what's been happening in government contracts, claims, and disputes over the last fiscal year.
Nice. So do you have any maybe like overarching themes or trends that we can kind of like look to from last year?
Sure. We can discuss these in more detail, but we're seeing 5 big trends that we want to share today.
Okay.
First, new filings increased at both boards. Second, appeals were sustained at high rates, consistent with previous year's data. Third, the number of cases pending before the boards decreased. Fourth, ADR continued to be an effective tool for litigants. And fifth, the boards are investing in modernization, accessibility, and enhancing their technology.
Okay, well, it sounds like we have a lot to discuss. So let's go ahead and dive into that very first trend. You mentioned an increase in filings. What exactly did that look like?
The number of appeals docketed at both boards increased as compared to prior years. The ASPCA docketed 371 appeals in fiscal year 2025, which is a 34% increase over last year. The CBCA docketed 390 new cases, which is a 22% increase over fiscal year 2024. CBCA is different than the ASPCA in that their docket includes 12 different case types. If you look at just Contract Disputes Act appeals, there were 222 appeals docketed at the CBCA last year, which was still a 32% increase over fiscal year 2024.
Wow, so those percentages are definitely an increase. I wonder if there's a reason that we can maybe pinpoint or discuss a little bit more that would have contributed to that surge.
It's hard to say what's driving this increase, particularly because you're looking at a wide range of agencies, different budget priorities, and different subject matters. The increase in CDA appeals last year probably shouldn't be overstated. It doesn't appear to reflect a sudden wave of terminations, a sharp policy shift, or a new surge in conflicts. Nor does it resemble traditionally higher rates of filing pre-pandemic when the boards routinely docketed closer to 500 to 600 appeals each year. Fiscal year 2025 seems to be a normalization following several years of decreased filings. The filings peaked after peaking during the pandemic era, filings trended downwards in fiscal year 2024 and had a low point at 276 cases last year. Against that backdrop, fiscal year 2025 seems to be more of a return to pre-pandemic levels.
Okay.
Assuming trends in the claims arena is inherently more complex than something like a bid protest because of the timing. Unlike protests where you generally see a filing within 10 days after the triggering event, CDA appeals are preceded by a mandatory administrative process. Contractors have to submit a claim to the contracting officer and await a final decision before they can appeal, a process that can take many months and up to a year. As a result, the appeals filed in fiscal year 2025 probably stem from disputes that happened in 2022 through 2024 rather than developments in the last year. So all of this together suggests that this wasn't anything unusual, but rather the resolution of claims that had taken many years to come to a conclusion and a return to pre-pandemic levels.
Right, and that's a good distinction between the claims and the protests too. So what about agencies? Were there any agencies that had more activity than others this past fiscal year?
Definitely. The U.S. Army Corps of Engineers has had the most appeals at the ASPCA, which is consistent with prior years. The ASPCA has always had a high number of construction appeals, but it's also noteworthy that DLA had a substantial increase last year, jumping from just 11 appeals to 33. At the CBCA, the VA had the most appeals with 70,
Oh, wow.
USAID had 43, and GSA had 36. With the changes in many of the civilian agencies, such as USAID and GSA, it will be interesting to see what CBCA's numbers look like in next year for each category.
Yeah, no, it sounds like we'll have to do another episode to talk about that. All right, so we've talked about filings, we've talked about agencies, but what about different contract types? Were there any maybe policies or different types of procurements that were driving those numbers?
So high appeal counts can sometimes be mistaken for high conflict, but in federal contracting, that doesn't tend to be the case. It's
Okay.
usually a function of scale. Agencies with the biggest procurement budgets inevitably generate the most disputes each year.
Mm-hmm.
The US Army Corps of Engineers consistently accounts for a large number of claims because it sits at the intersection of scale and claim-prone contracting.
Right.
The Corps oversees the federal government's largest construction portfolios, which encompass civil works, military construction, and environmental projects. Construction projects are inherently dispute generating. They have site-specific conditions, design ambiguities, differing subsurface conditions, weather impacts, and long performance periods. All of those frequently drive cost and schedule impacts that can't be fully measured until late in performance or after completion. When those realities are paired with the sheer contracting volume that the Corps has, formal claims and appeals are not only common, but often unavoidable.
Right.
With respect to the VA, people often forget that VA consistently ranks as one of the government's largest procuring agencies, with a procurement budget second only to the DoD. It oversees a vast portfolio of construction, facilities, medical services, and IT contracts, and administers hundreds of medical centers and regional offices. Given that scale, it's not surprising that VA generates the highest number of new appeals at CBCA. High appeal volume here reflects the size and complexity of VA's contracting activity, and is sort of a natural byproduct of administrating one of the largest acquisition programs in the country.
Right. No, that sounds great. All right, so that's all for trend one. Let's dive into the second trend, which is the rate of sustained appeals. What kind of trends can we see regarding those rates with the two boards?
Both boards continue to be a good place to litigate as a contractor.
Okay.
They had high sustain rates. At ASPCA, 67% of appeals that reached the merits were sustained, which is consistent with rates in previous years. And at the CBCA, if you isolate just CDA appeals, not looking at their other cases, their sustain rate was 61% for appeals that reached the merits, which is also very high.
Okay. Does that say anything about those initial decisions made by the contracting officer?
I don't think so. Sustain rates don't suggest that contracting officers are being unreasonable or that their initial decisions are careless. Instead, it just reflects how disputes evolve once they enter the process at the boards. As an initial matter, it's important to point out that many sustained appeals are not wholesale reversals of the contracting officer's position. Instead, sometimes they reflect partial relief, and a reduction in quantum, or an acceptance of an alternative legal theory rather than a complete rejection of the government's case. In that sense, sustained statistics often capture a refinement of the party's position, not a repudiation of the initial decision by the contracting officer.
Okay.
Also, cases that proceed all the way to the merits decision by the board are highly filtered. Weak cases tend to resolve earlier through negotiation, withdrawal, or settlement, and only the most developed, most documented disputes reach a final decision. So as a result, board merits decisions disproportionately involve close questions, complex facts, or significant legal issues, which may produce higher sustain rates. And finally, contracting officers have to make their decisions on incomplete records often, and under institutional constraints, while the boards decide cases after discovery, expert testimony, and adversarial briefing. A higher sustain rate reflects the difference between administrative decision-making and adjudication, not necessarily an error rate. However, this dynamic underscores the importance for agencies and for contractors of continually reassessing litigation risk as the record develops.
Yeah, that makes sense to kind of keep everything on a rolling basis.
Absolutely.
Okay. All right, so let's move on to trend number 3, and that's going to be pending cases. I know that that's something everyone's always concerned about, is like, what's the status of my case? So what did that look like in 2025?
The board judges continued to be very busy in fiscal year 2025. Despite higher numbers of appeals being filed, the ASPCA reduced its number of pending cases. The ASPCA had more than 900 pending cases in fiscal year 2020 through 2023, but has substantially reduced that number of pending cases in recent years and only had 748 pending cases in this last year. Of that number, 200 were reported to be suspended, which generally means the parties are in settlement, and 68 appeals were in ready-to-write status, waiting for a decision from a judge.
Okay.
The CBCA doesn't break down pending appeals in the same way,
Mhm.
but it had 375 pending appeals, which is a slight increase over last year. This number seems to reflect a higher volume of cases that were filed rather than a slower processing rate by the board.
Okay, right. Well, that's good to know. I know that reducing that docket is definitely a win for the boards. So even though the ASPCA reduced its backlog significantly, it still seems like the Defense Contracting Management Agency still had a high ratio of pending cases. Can you talk to me about a little bit of why that's the case and maybe why it's taking longer for those to be resolved?
Sure, it's an interesting statistic, and the cause is difficult to pinpoint. But there are two things to keep in mind.
Okay.
First, DCMA cases are disproportionately complex.
Mhm.
They frequently involve cost allowability, CAS compliance, indirect rate disputes, defective pricing, or business system determinations. Those are issues that are fact intensive,
Mhm.
accounting heavy, and rarely amenable to early resolution. Those cases often require extensive discovery,
Mhm.
expert analysis, and coordination with auditors like the DCAA, which naturally lengthens the timeline of the case.
Right.
DCMA cases often also involve portfolio-wide or systemic issues rather than contract-specific disagreements.
Mhm.
A single appeal can implicate multiple contracts, fiscal years, or business segments, which raises the stakes on both sides and makes resolution more difficult. In those circumstances, parties are understandably cautious about
Mhm.
settling in ways that could have broader precedential or financial implications.
No, that makes sense. And I mean, we're lawyers, we're not mathematicians.
Exactly.
Okay, so let's move on to your fourth trend that you mentioned, um, the alternative dispute resolution. So that's also kind of like a favorite aspect of mine because it allows both parties to really have a hand in the resolution of the case. But how did that look before the boards?
ADR continued to be an effective tool for litigants before
Okay.
the boards. The ASPCA reported that in fiscal year 2025, it had 80 matters diverted to ADR. And for every single one of those 80, the case was either resolved, withdrawn, or remained actively engaged in ADR at the end of the year.
Oh,
None
wow.
of them were deemed unsuccessful.
Okay, that's good.
The CDCA reports on their data slightly differently, but it reported conducting 53 ADRs and resolving 28 disputes before a hearing.
That's really impressive. Um, what about off docket ADRs? Can you talk to me a little bit about what that is and why contractors may want to consider that as an option?
Sure. Off-docket ADR is a method by which parties can seek assistance from a board without having to file a notice of appeal.
Okay.
It can be useful for contractors that want to keep a positive working relationship with an agency but need some support in resolving an issue.
Right.
The ASPCA reported handling 5 off-docket ADR matters last year. Off-docket ADR is probably most effective where the parties have an ongoing relationship and need a prompt resolution to avoid performance impacts, or where a dispute presents a narrow issue of contract interpretation that can be resolved without extensive factual development.
Okay, well, that's good to know. Alrighty, so we know that ADR is effective, but why exactly is that the case? Can you maybe explain why that's such an effective tool?
Sure, there's a lot that I could say here, but I'll highlight a couple of
Okay.
things. ADR is effective because it mitigates the structural inefficiencies of litigating against the federal government under the CDA. It restores flexibility that litigation lacks. Once an appeal is filed, the dispute moves into a rigid, resource intensive process governed by pleadings, discovery, and briefing schedules. ADR allows the parties to step outside of that framework and consider practical resolutions like
Mhm.
partial relief, prospective adjustments, or phase solutions, things that a board or a court couldn't impose but might better serve the program and performance needs.
Okay.
Second, ADR can accelerate risk assessment in a system that otherwise can move quite slowly.
Mhm.
Merits decisions at the board can take years, but by contrast, early neutral evaluation by a mediator provides the parties with timely feedback on the strengths and weaknesses of their
Mhm.
positions. And finally, ADR recognizes that government contractors are long-term federal partners, not one-off litigants. Most contractors that are engaged in CDA disputes have dedicated their businesses to performing federal
Mhm.
contracts and will continue working with the government long after the dispute is resolved.
Right.
ADR allows the parties to address their disagreements without transforming a routine contractual dispute into a prolonged battle that
Mhm.
could strain their relationship, distract from performance, or impede their future collaboration across programs and agencies.
Right. So it sounds like it's a great tool to maintain that relationship and still get a resolution. Okay, well, I can't believe that we're already at our fifth and final trend, and that is going to be modernization, accessibility, and enhancing technology. So, what do those advances look like at the board?
Following changes in the COVID era, the boards are continuing to offer both in-person and virtual hearing formats, which provides helpful options for litigants.
Mhm.
The CBCA made substantial updates to their facilities in fiscal year 2025. They converted a courtroom and a conference room to support hybrid hearings and mediations. Similarly, the ASBCA is soon moving to new offices and will have upgraded technology in the new space, making in-person and virtual formats easier.
Mhm.
The CBCA also debuted its electronic docketing system, which significantly modernized the case management process. And finally, the ASBCA published guidelines for the use of AI,
Okay.
and CBCA is evaluating the use of AI by parties.
Yeah, no, that sounds great, and it sounds like it's going to be beneficial for both contractors and agencies. I'm personally interested in, as kind of like AI continues to develop and become integrated in our workflows, how those policies and procedures continue to advance and improve as well. Well, this was such a great conversation. I feel like it went by so fast.
I agree.
Where can we get more information on these trends and takeaways?
If the audience wants to review the trends we discussed today, they could check out an article written by Elizabeth Whitwer, Dan Russell, and me titled Top 5 Trends and Takeaways from the Fiscal Year 2025 ASBCA and CBCA Annual Reports.
Well, we will definitely include all of that information and the link to that article in our show notes below. And that includes this episode of Grant or Deny. Thank you.
Thanks.